So I had wondered the other day if some of the bigger channels had just kind of brushed aside Maddie's case for now. But then this morning when I got up, I saw there was a new live stream from the docket. Now, if you caught that live stream, you may have ended up as confused as I was. Because Eric basically brought out a new document that's been filed, which is relating to Stearns's case for Maddie's death. So basically a filing has been made on behalf of Stearns which requests a change in the directions that are to be given to the jury in that case. Now, at first glance, and I must admit I came away from listening to when Eric read the document, at first glance it seems counterintuitive. It seems like what is being requested is actually going to work against Stearns. And my first thought was, why the heck would you do that? So I took a bit of time to think about it, dug a little bit, and I wanted to go through it all with you guys so that hopefully by the end of it we can all understand what's going on here. So I am going to read through the document. Don't stress if that's a little bit confusing at first. I will do my best to explain things as we go along. And then I'm going to pull it apart and explain what I believe is actually going on here. So let's jump in and we'll start with what has actually been filed before we start to pull it all apart. Now, for anyone who wants a copy of this for themselves, I will provide a link in the description. You can actually thank the docket for this. He actually provided that link during his live stream. So I will provide you that link if you want to get a copy of this document for yourself to look at. So definitely a huge shout out to the docket for making this available. So if you look at the top of the page, this was filed on the 18th of December, which by my calculations was yesterday, given that today in Australia is the 20th, so you guys are probably still on the 19th. Either way, looks like it was filed yesterday. And what is the motion? Defendant's motion to modify jury instructions regarding the defendant's burden of proof. Okay, well, I would love to skip over the fancy legal speech. I think it's going to be easier for you guys to follow it if I don't skip over bits. So I'm just going to read through and then I'm going to pause as we go along and explain what's going on. So comes now the defendant, Stephen Stearns, by and through his undersigned attorneys, and files this motion to modify jury instructions regarding the defendant's burden of proof. In support of this motion, Mr. Stearns would state as follows. So basically what they're saying, they want to change what he has to prove to the jury in terms of burden of proof regarding mitigating circumstances. They essentially don't want him to have to prove any mitigating circumstances. That sounds odd, but it will come clear as we go through. Okay, so point 1. Standard Jury Instruction 7.11 reads in pertinent part. It is the defendant's burden to prove that one or more mitigating circumstances exist. Mitigating circumstances and need not be proven beyond a reasonable doubt. Instead, the defendant need only prove a mitigating circumstance by the greater weight of the evidence, which means evidence that more than likely not tends to establish the existence of a mitigating circumstance. Okay, that is a huge mouthful. And what they're saying is that normally the defendant has to prove the existence of mitigating circumstances. Things that could outweigh the aggravating circumstances. And what it's saying is that unlike when you're proving a case, it doesn't have to be proven beyond reasonable doubt. So they can be just something that can be proven to an extent, but not to the extent of beyond reasonable doubt. They only need to prove a mitigating circumstance by the greater weight of the evidence, meaning that there should be something in the evidence that can be used to suggest mitigating circumstances. It doesn't have to be huge. That's my understanding. If you determine by the greater weight of the evidence that a mitigating circumstance exists, you must consider it proven and give that evidence such weight as you determine it should receive. So basically, if the jury can see that the evidence shows mitigating circumstances, things that are positive for him, that put him in a more positive light, they have to take those circumstances into account. And they have to work out the weight of those circumstances, basically. You need not reach a unanimous decision about whether the defendant has proven the existence of a mitigating circumstance. Any juror persuaded as to the existence of a mitigating circumstance must consider it in this case. So they're saying that not every juror has to agree that something is in fact a mitigating circumstance. They just have to, if an individual juror believes something is a mitigating circumstance, they have to take that into account when they make a decision. So essentially what that whole paragraph is saying is that normally a jury is expected to consider mitigating circumstances when they are making their decision in a case, and to weigh them up against aggravating circumstances. So somehow that would have an effect on whether they believe guilt beyond reasonable doubt. Mitigating circumstances can lessen guilt. So essentially, normally, if you could say there's enough mitigating circumstances, then you can turn around and say a person's not guilty. So in a domestic violence case where perhaps the person who is being assaulted defends themselves and accidentally kills their assailant, that's mitigating circumstances. And the jury can then turn around and say that outweighs the aggravating circumstances. Perhaps they were holding a knife. Therefore, they are not guilty. So normally, it's a positive thing. Let's move on to the second paragraph. So here it says, Florida statutes does not impose a burden of proof on the defendant to prove mitigating circumstances. Rather, it states that in cases where the court imposes a death sentence, the court shall enter a written order addressing the aggravating factors and the mitigating circumstances reasonably established by the evidence. So they're basically saying that in the case of a death sentence in Florida, then in terms of the mitigating circumstances, they should actually be outlined as part of an order which addresses both the aggravating and mitigating factors. I'm not sure where the relevance of that is, other than the main part at the beginning where they're saying that normally in Florida the burden of proof is not on the defendant to prove mitigating circumstances. I'm sure that will become apparent as we go on as to why that is important. So paragraph 3, Mr. Stearns requests that any language that places a burden on the defence of providing mitigating circumstances be removed from the instructions to the jury. He doesn't want his defence team to have to prove mitigating circumstances to the jury. Now that sounds odd, doesn't it? Because you would think that for him, he would want to be able to prove mitigating circumstances to say that he's actually not as culpable and he shouldn't be convicted because of these mitigating circumstances. Logically, you would think that would be the case. But in this case, he doesn't want to have to, he doesn't want to go there. He doesn't want to talk about mitigating circumstances. Interesting, and it will become clear, trust me. Okay, paragraph 4. Florida's capital sentencing scheme begins with a determination of whether a defendant is eligible for death penalty, which requires a unanimous finding that a statutory aggravating factor has been proven beyond reasonable doubt. Next, the jury must consider whether sufficient aggravating factors exist and whether aggravating factors exist which outweigh the mitigating circumstances found to exist. So essentially, for them to make a decision based on reasonable doubt, that is based on aggravating factors. And I'll go through aggravating factors after I finish with this document. But essentially, they're the things that go against him. The evidence that shows that he should be convicted. And then after those aggravating factors have been established, then the jury must decide whether there are enough. So can these things, does the evidence prove beyond reasonable doubt, essentially? But normally they have to weigh it against mitigating circumstances. So like my previous example, if a person in a domestic violence situation defended themselves with a knife, then the jury might decide, okay, they were violent, they killed this person with a knife, that's the aggravating circumstance. However, they were doing it to save their own life. That's the mitigating circumstance that's going to outweigh the aggravating circumstances. So in a case like that, it would be important to establish a mitigating circumstance. And they would only have to prove that this person believed that their life was at risk. They wouldn't have to prove beyond reasonable doubt that their life was at risk for that to be considered a sufficient mitigating factor. Okay, so paragraph 5. The Supreme Court has exposed doubt whether it is even possible to apply a standard of proof to the mitigating factor determination. So I will just mention the case for the precedent because otherwise it sounds like I'm talking about a state. So Kansas versus Carr. Maybe it is talking about Kansas. In which case, I'm not sure how that necessarily applies to Florida statute. But let's listen anyway. The facts justifying death set forth in the Kansas statute either did or did not exist, and one can require the finding that they did exist to be made beyond reasonable doubt. Whether mitigation exists, however, is largely a judgment call or perhaps a value call. What one juror might consider mitigating, another might not. And of course, the ultimate question, whether mitigating circumstances outweigh aggravating circumstances, is mostly a question of mercy, the quality of which we know is not strained. Now, for all those words, I think essentially they were saying that looking at whether mitigating factors outweigh aggravating factors is subjective, that it may vary from juror to juror because of their own personal values, etc. Now, I don't know why this should be something that is considered in this particular case when it is always applied in every other case. I'm not entirely sure what the point is here, other than they're saying that they don't trust the jury to put enough weight on mitigating circumstances, is what I'm thinking. If my theory on this whole memorandum is correct, I don't even know why this paragraph is relevant. Okay, I hope you're still with me on this, because once you start putting a legal speech in, it does become a little bit confusing. But I promise I will explain it all once we get through this. Paragraph 6. Florida's procedure follows the same rules and thus is similarly, I can't even say that properly, difficult to assign a standard of proof to the mitigating circumstances in Florida's statutory scheme. So they're saying that even though the Kansas precedence technically doesn't apply in Florida, the fact that Florida follows the same rules means that it should apply. Whatever, Stefan. Okay, paragraph 7. Standard instruction does not follow the law as set out in section 921.141 Florida statutes and is therefore incorrect statement of law. Okay, that is a highly subjective point. They are basically now attacking Florida's legal system by the looks of it, saying that the way they give instructions to juries is wrong in Florida. Let me know if you read that as being different from that, but that's my interpretation. Paragraph 8. The standard jury instruction 7.1 regarding the burden of proof for mitigating factors denies Mr. Stearns a fair trial and due process under the Florida Constitution and the 6th, 8th and 14th Amendments to the United States Constitution. Wherefore Mr. Stearns respectfully requests this Honourable Court enter an order removing from the jury instructions any language that places on the defence the burden of proving mitigating circumstances. So essentially he's saying that if he has to try and prove mitigating circumstances, that's going to deny him a fair trial. You would normally think, like I said, that someone would want to prove mitigating circumstances in their trial, especially when they're fighting a death penalty. You'd think they'd want to pull out all the stops to avoid a conviction. But apparently, according to Stearns, for him to have to prove mitigating factors, that's denying fair and due process. So, what the heck is going on here? Why would someone turn around and say that they want jury instructions not to include the part where the jury considers mitigating factors, when mitigating factors could be the thing that allows them a lesser sentence or allows them a not guilty from the jury? So let's dig into it. So basically what they're talking about is aggravating factors and mitigating factors. And aggravating factors are the factors indicating higher culpability. the things that make a person look guilty or more guilty. Mitigating factors are factors indicating lower culpability, the things that make that person look less guilty. And if you think about using a set of scales, then basically, normally, a jury has to consider both, and they can really only give a guilty verdict if the aggravating factors do outweigh the mitigating factors. If the mitigating factors outweigh the aggravating factors, then they will give a not guilty verdict. What Stearns wants to do is remove any instructions to do with mitigating factors, meaning that all the jury has to go on is aggravating factors for making their decision. That's my understanding of what that whole memorandum means. Why would you do that, especially when a death penalty is on the table? Okay, to understand why he would do that, we need to have a look at what various aggravating factors could be in Stefan's case and what mitigating factors could be in Stefan's case. Now, basically what I've done is I've looked at possible aggravating factors, not definite aggravating factors. So there are some things here that may not actually, in his trial, come up as aggravating factors. But I think it's worth us considering them as we look at what they are. So what are aggravating factors? These are the factors indicating higher culpability, the things that show that a person is guilty. These can be planning of an offence. Now, I think we can agree, in Stefan's case, while he may not have planned to unalive Maddie, I think given his addiction, he was certainly planning on doing what he would normally do with Maddie in that upstairs bedroom or wherever it was that it occurred. So he was planning on doing stuff to Maddie. So he was planning an offence. The second point, commission of the offence for financial gain, where this is not inherent in the offence itself. What does this mean? If they have proven that his CSAM images were being traded or that he was getting money for them, so if they have discovered that that is the case, and he took any images or any video footage that night, this comes into play and becomes an aggravating factor. Yes, it is also a factor in the other trial, but it can still be considered as an aggravating factor in the trial for Maddie's death. High level of profit from the offence. Once again, if they can prove that he's been making money out of his images, if he took an image that evening or a video that evening and they can prove that he was going to make a profit from it, then that is an aggravating factor. Then you have an attempt to conceal or dispose of evidence. Well, heck, we've got plenty of that. We have him removing Maddie from the house. We have him placing her in the trunk of his car to obscure the fact that she was there. We have him resetting his phone twice. We have him heading down to Northport And I believe that they will prove that he went down and removed the hard drive from his computer, given that the FBI have proven that he accessed that computer when he went down there, which suggests that he did enter the house. You have Chris's comments that the hard drive was in the computer when Stefan went down there, meaning that he must have gone down there to access his Google Drive and then removed the hard drive and either disposed of it or destroyed it. Either way, there was an attempt to conceal or dispose of evidence. And of course, we know that he took Maddie and placed her out under the bamboo thingies. That is also an attempt to conceal or dispose of evidence. He also threw out the backpack, the laptop, the Crocs. So there's plenty there in terms of aggravating factors. I haven't even finished with this list. This is only the first part because there was too many to fit on one page, so let's keep going. Okay, deliberate targeting of a vulnerable victim. That is well and truly aggravating factors. He did target Maddie. The acts that he was doing from when at least 4 years previously. He targeted her. And even if he didn't target her directly to unalive her, he targeted her for his own satisfaction, and it resulted in her death. So it was still deliberate targeting of a vulnerable victim. So that's definitely an aggravating factor. Commission of an offence while under the influence of alcohol or drugs. We don't know, but if they can prove that he had taken any sort of drugs, then yes, that is an aggravating factor. Don't forget that one of the things Jen mentioned was that he had a vial of Viagra or whatever the other thing was. So if they can prove that he actually took Viagra, he was under the influence of drugs. Possibly not alcohol. Still an aggravating factor. Were they to find any other drugs in his system? Aggravating factor. Abuse of power. Well, that's a slam dunk, isn't it? Obviously, in the relationship between him and Maddie, and I don't mean relationship as in partners or S or anything like that, just the balance of power. He was the person in a position of power. He was the adult, she was a 13-year-old. He had power and he abused it. And abuse of a position of trust. Hell yeah. Supposedly, Jen trusted him to be in, I can't even say that. Supposedly, Jen trusted him. What a load of crap. But if they can prove that that's what she's saying, then that's still an aggravating factor. Maddie, to some extent, must have trusted him. That's an aggravating factor. The fact that he was an adult in Maddie's life, that is a position of trust. That is a position of power. So he abused both of those. They are aggravating factors. Now, again, I'm not saying that these are things that could necessarily be used in trial, but they are possibilities. So factors indicating a more than usually serious degree of harm are also considered aggravating factors. An especially serious physical or psychological effect on the victim, even if unintended. In this case, yes, there was a serious effect because it cost Maddie her life. So this is a more serious aggravating factor. A sustained assault or repeated assaults on the same victim. I hate even thinking of this, but how much did Maddie go through that night before she finally lost her life? If they can prove that it was sustained, then that is an aggravating factor, and it is a more serious aggravating factor. Even, I suspect, the long-term abuse could be considered a more serious aggravating factor. So it continues with looking at factors that are more than usually serious degree of harm. The victim is particularly vulnerable. Yes, I think we can all agree Maddie was particularly vulnerable. She was placed in a position of vulnerability. She was given medications to make her drowsy, to make her sleep. If he had given her additional medications, then she was particularly vulnerable. She was only 13. She was a child. That makes her particularly vulnerable. The location of the offence. Here they've got, for example, in an isolated place. If the offence occurred in that upstairs bedroom, as a lot of the evidence points to, the fact that that room had multiple locks on the door means that it is a more serious aggravating factor, meaning that there is the possibility of him locking them in there and nobody being able to intervene. And then you have additional degradation of the victim. For example, taking photographs of a victim as part of AS offence. So once again, did he do anything that night? Did he take photos? Did he make a video? Because if he did, that is another majorly serious aggravating offence. So if we look at all these aggravating circumstances, then wouldn't you think that it would actually be super important to be able to establish strong mitigating circumstances and for the jury to be instructed to consider those strong mitigating circumstances when making their decision? Because when you look at all these aggravating factors, right now, he's not looking like he's in a very good position. So surely you would think, well, maybe his only hope is mitigating factors. So let's have a look and see what some mitigating factors could be in a case of this sort. Now remember, these don't have to be established as well as aggravating factors. It's not a burden of beyond reasonable doubt. It just has to be established. So mitigating factors indicating lower culpability. These are some of the things. A greater degree of provocation than normally expected. Could Stefan claim that Maddie provoked him? No jury is going to buy that. No jury is going to buy that a 13-year-old girl provoked a 37-year-old male to the point where he then unalived her. So we can pretty much wipe that away as a possible mitigating factor. Mental illness or disability. Now, there has been debate, and we know this issue was raised by his parents. The possibility of him using the defence of a brain injury, acquired brain injury. Now, this could be considered quite a substantial mitigating factor in a case. Could it be sufficiently proven? Here's the thing, we know from Stefan's parents that what they've described sounds like more like a concussion than an acquired brain injury. There is no trail from when that injury occurred. From listening to his parents, he had that injury and he received no further treatment for it. There were no other events in his life that pointed to actions resulting from that acquired brain injury. So I'm thinking that's off the table. I'm thinking they have failed to find any documentation. They cannot prove it has been an ongoing problem. There is no medical documentation to prove the existence of it, so they can't run with it. Because otherwise, I think he wouldn't be wanting to remove mitigating factors in terms of instructions for the jury. So I think we can throw that out the window now. Now, the other thing that could be considered a mitigating factor, the fact that the offender played only a minor role in the offence. People have debated, well, we heard him say to his parents, I didn't start it. And as Chris said, you might not have started it, but you participated. Now, I think in this case, some people have debated whether or not Jen was responsible for Maddie's death, which there is absolutely no evidence of that whatsoever. All the evidence points towards Stearns, and I think had they even a sniff of evidence pointing towards Jen, they would certainly want to use that as a mitigating factor, meaning that they really wouldn't want to lose mitigating factors in terms of instructions to the jury. So I think we can take this off the board too. There is no evidence to show that Stefan played only a minor role in the offence. So here we've got three things that could be considered mitigating factors, and already these things we can pretty much wipe away. They wouldn't apply to Stefan. What are some other things that could be mitigating factors? So these mitigating factors are under the heading of offender mitigation. In other words, things that come directly from the offender, which could be considered mitigating circumstances. The first one, genuine remorse. Well, as far as we know, the only remorse shown by Stefan was that he misses Maddie, and that he didn't mean it to go that far. That's not genuine remorse. We know what he's like. He's a narcissist. He has chosen not to accept responsibility for his actions. In fact, he made the choice to try and cover up everything that he did. So we can skip that completely. The second one, admissions to police in an interview. Well, heck, we know that never happened. All the interviews we've heard, he did his best to be the caring partner of Jen, who was just so worried about Maddie, knew nothing about what happened to her, and he was so concerned, and he was so innocent, he did nothing. So we can skip that one as well. And the third one, ready cooperation with the authorities. That would be saying, yes, I did it, this is where she is. Or explaining what he did. Basically admitting guilt. Taking them to where he left her. Did he do that? No. Not at all. He took them on a wild goose chase. So they called out all their dogs, or they called out a bunch of dogs, went to the area around the church where he thinks it was kind of about here, possibly where he may have dropped her off, wasted resources searching around an area where she was nowhere near. Did he ever give them any help with finding Maddie? Not a chance. He spent the whole time trying to hide his guilt, so he did not cooperate with authorities. So when you break it down like that, what initially seems like a really weird request, him saying that he doesn't want the jury to be given instructions in terms of considering mitigating circumstances, totally makes sense. There's no mitigating circumstances here. If the judge were to say to the jury before they went into deliberations, now you have to consider aggravating circumstances and mitigating circumstances, what have they got? They've only got aggravating circumstances. They're going to head off into the jury room and say, well, hang on, we're supposed to consider mitigating circumstances, and if they outweigh the aggravating circumstances, but there's no mitigating circumstances here. So there's only aggravating circumstances, so we have to convict him. Stearns doesn't want that to happen. So he does not want mention to the jury of the need to consider mitigating circumstances, because there are no reasonable mitigating circumstances that his defence team can put forward that could possibly come close to outweighing aggravating circumstances. And if like I said, if the judge were to say you have to consider mitigating circumstances, that is highlighting the fact that there are no mitigating circumstances. But if the judge doesn't tell the jury that they have to consider mitigating circumstances and weigh them against aggravating circumstances, then all the jury has is that they have to decide that he is guilty beyond reasonable doubt. They can only go by whatever evidence has been presented, and they're not going to even consider the fact that there's no mitigating circumstances, because that has not been brought up as a factor in their decision. Stefan basically doesn't want the jury to realise how much of a disgusting worm that he is, and to realise that he's got nothing going for him. The only way he can do that is by trying to convince the judge that they shouldn't instruct the jury to consider mitigating circumstances which simply don't exist. Because I can guarantee you too that in closing arguments, the prosecution, if the judge were going to be saying you have to consider mitigating circumstances, I can guarantee that in their closing statement, the prosecution would make sure that the jury are well and truly aware of the absence of any mitigating circumstances in this case. Of course, if Stefan had a quarter of a brain cell, he would realise that the only outcome for him is a guilty verdict, and would avoid the drama of a trial. Avoid putting the people who cared for Maddie through a trial, which we know that's not Jen, but I believe that there were people who did care for Maddie. He should just admit his guilt. Trying to obfuscate by having the judge not instruct the jury to consider mitigating circumstances isn't going to make any difference. He's guilty. He knows he's guilty. He knows there's no mitigating circumstances that would save his ass. That's why he wants that instruction removed. Pure and simple. So, I hope that I have managed to clarify things for you, and that you can now see why that memorandum exists. Personally, I think the judge is going to squash it, because they're going to realise, well, hey, you are such a disgusting worm that the jury needs to see that there are no mitigating circumstances. But, you know, at the end of the day, he deserves everything that comes at him. He should make a plea deal rather than have people go through the agony of a trial. But he won't, because he's such a narcissist. Instead, I'm guessing this is only the start of many memorandums from this loser. So, thanks for listening. If you are new to my channel, please subscribe. Also, please hit the like button and leave a comment below. Let me know your thoughts on what's been discussed in this video. Let me know your thoughts on Stefan. Thanks, and I'll catch you in the next one.